Media in Society. This is Media Regulation Part 2. Last time we were discussing informal rules and controls. Now we're going to talk about formal rules and controls involving the media. As we discussed, the most formal rules and controls in American society are constitutional guarantees. According to these guarantees, we have these basic rights. We have the right to a fair trial. The trial must be timely. We are entitled to an attorney. We will be judged by an impartial jury, things like that. The right to privacy. We have the right for our business and personal matters to not become public information. And we have the right to property. We can own property if it's legally attained. Now let's discuss that a bit. One of the most basic conflicts involving mass media is linked to this right to own property and to control and benefit from it. In the media realm, property usually means intellectual property. The term intellectual property refers broadly to the creations of the human mind. Intellectual property rights protect the interests of the creators, the producers, by giving them ownership rights over their creations. This can include literary and artistic works such as novels and poems and plays and films and musical works and artistic works such as drawings and paintings, photographs, sculptures, architectural designs, things like that. But they also include trademarks. Trademarks include things like logos for Starbucks and Nike, and for the media such as Fox News' fair and balanced phrase. It's a phrase the network trademarked in 1998. They own it, essentially. This also involves inventions and patents, and also industrial designs, like the design of a package or of a car, the shapes and the patterns and the designs. All of that is very important because those things are considered one of the main factors which eventually influence consumer preference for one product over another. And there's a whole body of legal work of intellectual property known as copyright law. Copyright law, which often deals with words, images, and also publicity, which is the attention given to someone or something by the media. Of course, we find words and images and publicity in and around a variety of mass media related activities, including those of performing artists, those of broadcasters in their radio and television programs, authors in their books, newspaper and magazine writers, things like that. The bottom line, generally speaking, nobody should simply use the words and images of others without their permission. This includes media organizations such as advertisers or PR agencies, or anyone who wants to use these words and images. They generally must pay the person or the organization, for doing so, or at least get their permission. You want to get that in writing. Otherwise, it's what's known as copyright infringement. Now, media, and really all of us, can use short excerpts from these materials, like I often do in lecture, under something called the Fair Use Doctrine, which is where short portions can be used to help review or for discussion. But you cannot reproduce whole texts and shows without, again, getting prior permission to do so. This is exactly why audio and video file sharing is considered to be wrong, because it violates copyright law. Now, a good example of this involves, believe it or not, this song, Happy Birthday to You. Let's see if we can roll that.
Happy birthday to you. Happy birthday to you. Happy birthday, happy birthday. Happy birthday to you.
Now, right now, I'm going to go back to that. The Warner Music Group actually holds the rights to the song. They own it. The melody was first published in the late 1800s, originally titled Good Morning to All, written by a couple of sisters, Patty and Mildred Hill. The song grew in popularity in the early 20th century, and in 1935 the copyright for the song was registered by the company that originally published the song for the Hill sisters. Later, that company was purchased by other companies, which were eventually bought by the Warner Music Group. So Happy Birthday to You generates about $2 million a year for that company, mostly from licensing in movies and television shows. This is exactly why, the chain restaurants that you might go eat in sometimes will sing different songs than Happy Birthday to You on your birthday. That's largely because they don't want to pay license fees. They make up their own songs. Right now, there's a lawsuit underway to return "Happy Birthday to You" to what is known as the public domain. So anyone then could use the song for free. Those supporting this lawsuit argue that copyright protection was never intended to basically last forever. It was mostly meant to make sure that the creator of intellectual property could be properly rewarded for their work. But the creators, the Hill Sisters, they've been dead for decades, and so they say they've long since been sort of paid off, as well as the companies that bought the song later, that acquired the song later. So that kind of covers formal laws about rights to things like property. Now let's discuss formal rules about rights to things like a fair trial, but then also the role of media. Does news coverage hinder a fair trial? I mean, do cameras, just being present, do they alter the workings of the courts? This is a perfect example of the clash of competing liberties. In this case, the conflict between free press, such as what we have in the First Amendment, and an accused person's right to a fair trial, which is covered in the Sixth Amendment. The debate over free speech and fair trial takes really two forms. Number one, it can be involving pretrial publicity or news coverage, which some people worry might deny a citizen his or her right to a sound judgment by an impartial jury, thereby denying that person a fair trial. And number two, there's always a question of whether cameras should be allowed in the courtroom, which on one hand supports the public's right to know, but on the other hand, it may alter the workings of the whole system, of the trial system, so the fair trial is not possible. Do cameras, for example, do they create a circus-like atmosphere where lawyers sort of play to the audience, and does that then affect the person on trial? In conflicts between the First and Sixth Amendments, courts have consistently decided in favor of fair trial, oftentimes deciding against the rights of the news media in a courtroom. Now, a big case, as you see here, where they worried that pretrial publicity made a fair trial difficult, that was the O.J. Simpson trial, where the former star athlete, he was an actor, he was a Monday Night Football host, he was accused of murdering his wife and a young man that she might have been having an affair with. Now, in cases like this, some courts will, move the trial to a different city, keep the jury away from the media and the public, keep key players from talking about the case, and limit or bar cameras from the courtroom, including microphones and any recording devices. Many states do usually allow cameras and recording. Federal courts do not. Now, Colorado allows cameras and recording devices, but the media must ask for permission from the judge ahead of time. So the judge then takes input from different people in the trial and then kind of makes a decision, including whether or not to allow recording devices. Now, for a humorous response to these sorts of rules, let's take the case of what's called the puppet court. There was a Cleveland TV station that responded to a judge's order that there be no cameras allowed in the coverage of a particular court case. And what the station did was they would act out the court transcripts, which were accurate, but they would use puppets, as we see here. Kind of funny.
Emerald. Now it's time for our daily lampooning of the Jimmy Damore trial. Sometimes absurd, frequently comical, and always circus-like testimony at the heart of that county corruption trial. The testimony is real. The puppets are not. Tonight in the Puppets Court.
Welcome back to Puppets Court. The testimony you're about to hear is real. On the stand, Ferris Kleem, who admits to the judge he paid for the Vegas trip for Jimmy Damore, including $8,000 in gambling money and one prostitute named Suzanne.
Did Suzanne indicate how much money she wanted?
I remember thinking if it was more than 1,000, I wasn't going to do it.
Did you ever describe Mr. Damore to Suzanne?
Yes, I did, after I gave her the money.
And how did you describe him?
I said, he's a very nice man, but he's, large.
Ferris!
Yeah, was that the best or what?
Yeah, she's good. A little chatty, but good.
I think you get the idea. I think you have to decide the ethics on something like this. I think that news station felt that it had no choice but to do something like that, and it was pretty effective. Now let's talk about other clashing rights that we've mentioned before involving the free press, or First Amendment, versus privacy, which is the Fourth Amendment right. Basically, the right to be left alone. Privacy laws provide protection against intrusion. So you can't enter someone's physical private space, that is their private property, unless invited. That includes media people, including journalists. Also, privacy laws protect against embarrassment. a reporter might come across true information that was not meant to be released by a private citizen. Case in point on something like this, 1975, Oliver Bill Sipple, a former U.S. Marine. He's the guy who helped save President Gerald Ford's life by knocking aside Sarah Jane Moore, knocking aside her gun as she attempted to shoot Ford. 2 days after that, a columnist for the San Francisco Chronicle implied in a story that Sipple was gay. Sipple sued the Chronicle for unwanted publicity for that information. The court, interestingly, rules against Sipple because he had been written about being gay in magazines, and he had sort of admitted that to reporters before. And he was photographed marching in gay pride parades. And so the courts considered that information was deemed legitimate news, and they could, in fact, make that claim in that column. Now, a third way that privacy laws protect us is they protect us against what's called false light. That's when a journalist publishes untrue statements that alter an individual's public image in a way that she or he cannot control. The person who says they were harmed does not need to prove that their reputation was harmed. They only need to show that the coverage could harm their reputation. And a good example on this one was a case where ABC, the television network, had to settle multiple lawsuits after it ran a story about prostitutes and showed generic shots of men and women walking down a street just to have sort of generic images to go along with the story. The people who could be identified in those generic shots, they sued, indicating that it made them look as if they were doing business with prostitutes, and they actually won that lawsuit. And then the fourth way is misappropriation. That's using a person's name or image for commercial purposes without his or her permission. That's a no-no. Some more laws protecting our privacy from the press. Journalists cannot tap phone calls in this country. Think Rupert Murdoch and the News of the World scandal, which broke a few years back. Journalists cannot peer into private property with telephoto lenses. They can't break into homes. They can't break into offices or hospital rooms. A lot of this is determined by, sort of state by state as far as what journalists can and cannot do. For instance, hidden cameras or hidden microphones, they are allowed in Colorado, not allowed in some other states. Covert, kind of secret phone recordings. Again, some states say that both parties must know the call is being recorded, but some require that only one person knows, which is always kind of strange to me, but that's actually the fact in Colorado. So as long as you know, you can record someone's your conversation with someone else, but they don't need to know. It's not illegal, at least here. So the big question then, do public figures and politicians, do celebrities and others who say put themselves in the public eye, do they forfeit their right to privacy? For instance, if photographers take pictures in a public place of a newsworthy subject who can be seen with the naked eye, if you could look and see them, then the media are generally in the clear. So if you look over some celebrities doing something and you could just easily see them with just your eyes, then you could take a picture of them and that's okay. However, if the media physically intrude in any way on private areas, then the media could be in trouble. Case in point, Playgirl, the magazine, publishes unauthorized nude photos of Brad Pitt in 1997. Pitt sues for violation of privacy, and he argued that the pictures had been taken by a photographer who trespassed on the grounds of a hotel's private beach in the Caribbean, where Pitt was staying with his then girlfriend, Gwyneth Paltrow. And so note that Pitt was outside. He's on a beach, but it was considered private property. And he can only be seen with this really big telephoto lens. They consider that to be an intrusion. So the court sides with Pitt. The judge also orders a recall of the magazine. That meant that the magazines had to be pulled from newsstands and the subscribers had to be contacted and asked to send their copies back to the publishers. Interestingly, very few of the subscribers did, but it did have kind of a chilling effect on the media from then on. All right, that's the end of Regulation Part 2.